Good afternoon, everyone. My name is Robert Durante, and I'm a senior partner at Oatley Lehman. Joining me today, I have Oatley Lehman's founding partner, Roger Oatley, and Troy Lehman, one of my senior partners at Oatley Lehman. We're here today to give you an overview of Roger and Troy's latest edition of Addressing the Jury, Achieving Fair Verdicts in Personal Injury Cases. It's hard to believe that Roger published his first edition of this book nearly 24 years ago. Here we are, 2 editions later, and the book is better and more relevant than ever in its 3rd edition. For those of you not familiar with the book, this is the first and only Canadian book dedicated to practice before civil juries. This practical and easy-to-read book provides extensive guidance on how to apply and benefit from the concepts of courtroom communication and persuasion. It's a must-read for any trial lawyer doing our kind of book, our kind of work, rather. Okay, enough of my shameless plug for your book, guys. Let's get into some of the concepts and practical strategies you cover off in this 3rd edition. Roger, I learned literally nothing about jury trials when I went to law school back in the 90s. What is one of the most important things that law school doesn't teach us about winning jury trials?
Thanks, Rob, and it's a great pleasure to be with you guys. Hard to believe that I've been retired for almost 9 years. Yes, in law school, we're taught the very naive notion that judges and juries make all their decisions based on the facts and the law. The reality, though, if we're going to present a case successfully before a jury, is that we have to understand what I call the perception principle. And that, simply stated, is that what jurors learn, understand, and believe, and therefore take into the jury room, is based on what the juror perceives to be the truth. I think the very best and most timely example that I can think of is the dreadful experience that we're all living through with respect to Donald Trump. Donald Trump has so frequently stated, as have his allies, that he won the 2020 election, that so many millions of people who supported him believe that to be true, even though the rest of us and the courts, who heard over 60 challenges on that issue, know that it is not true. But it simply doesn't matter when so many people perceive that to be the truth. And Trump understands this perception principle. He uses it over and over and over again, telling people repeatedly that something that is not true is true. And because he says it so frequently, and because he says it as though it is absolutely the only truth, people perceive it. And if we analogize the many millions who support him to our jurors, we can understand the impact of the perception principle. And that, Rob, is the best example I can think of to illustrate what it is.
Thanks, Roger. It's a great way to tie that principle into what's going on right now in the US and Canada. I want to talk a little bit about the importance of themes, and we learn a lot about themes in the book. We learn a little bit about themes in law school. Troy, this one's for you. Can you tell us what this book teaches us about themes and trial stories and why they matter?
Yeah, like you say, Rob, we don't learn much about themes and the importance of themes in law school. It's 99% focused on substantive law and procedure and evidence. But what we're trying to do in a trial is to convince a jury that our position is right. And themes are really, really important when it comes to persuasion in the courtroom. And not just in the courtroom, but in other forms of communication too. And we talk about this in the book. For example, themes serve a really important purpose in a good movie. They help the audience decide who are the goodies and who are the baddies and why should they care. And they serve the same purpose, and it's even more important in a trial. Because as we all know, trials are incredibly complex, days and days of evidence, tons of information. And without a good theme, um, you just won't have the jurors focusing on what we want them to focus on. It's just too much information. So if you don't put time into developing good themes and a trial story, it's going to be pure information overload for the six people sitting in the jury box. And you'll have lost your opportunity to tell jurors in a simple way what the case is about and what it or why it matters. And that's what a theme is. And if you don't do it, they're going to make up their own theme. They're going to make up their own trial story, and it might not be helpful to your case. So it's absolutely crucial in my view. We talk a lot about this in the book, to spend a lot of time in your trial preparation and your focus groups to develop themes for the key issues in every case. And themes are really this. They're simple, understandable, and persuasive summaries of what the case is about and why your client deserves a good outcome. Because remember, these jurors have no clue what the case is about when they walk into the court in day one. Everything's foreign to them. The start of the trial process is incredibly foreign to them. And if you give an opening statement that goes on about the importance of the jury system, reviews a bunch of evidence without the focus of a theme, then you've lost a key opportunity. Because the jurors are going to sit through that opening still wondering, what's this case about and why does it matter? But if you put a good theme and put a lot of work into the theming and put it right up front, your opening, that will laser focus the jurors. This case is about adults entrusted with the safety of kids who fail to follow rules designed to keep kids safe. If that's your theme, then when you review the evidence, the jurors are going to focus on what you want them to. What are these rules about safety? Why did they exist to keep kids safe? Were they followed or not? And what was the consequence? So the theme becomes the device to control how the evidence is perceived, going back to Roger's perception principle, which is so important. And the themes provide a filter for jurors to sort through the evidence, which would otherwise be overwhelming. So I think it's maybe the most important part of trial preparation, theming. And there's lots of examples in the book about why themes make a difference with examples from real cases.
Right. And I remember a lot of good themes over the years, Roger, working with you. Can you give us a few examples of some good themes and mention some of the more memorable ones that stick out in your mind?
Yeah, it's been an interesting exercise preparing for this because I've had to think way back to come up with a couple of interesting cases that stand out. And I do have a couple for you, Rob. And I should say I particularly like the way Troy explained what a theme is and how it's so important. It's almost like putting up a Christmas tree without any ornaments on it. And then on Christmas Eve, everybody comes together with the ornaments and starts decorating the tree. And they know what to do with the ornaments because the tree is there. And it's a bit like that for jurors because they're hearing all of this evidence and where do we put it? And I think it's absolutely true to say that if you don't give a theme or a way of perceiving and organizing the evidence to jurors, they'll come up with a way of their own. And it probably won't be what you want it to be. So here's a couple of examples. One was an interesting case, and Rob, I think you were on the Tennant case with me in Hamilton.
I was.
It involved a fine young man who was sitting in the back seat of a car. And as far as he was concerned, he was wearing his seatbelt. But in spite of wearing his seatbelt, in spite of what it's supposed to do to prevent an injury, when the driver slammed into a tree, this young man, Bill Tennant, went forward into the back of the seat in front of him and suffered a loading injury to his spine that rendered him a high-level quadriplegic. Fortunately, before we took the case over, the lawyer in Hamilton, Dave Smythe, had the wherewithal to have an investigator rush out to find the car in a junkyard and to take a look at the seatbelt. And he discovered that a part was missing inside the mechanism that locks up the seatbelt to prevent somebody from moving forward as Bill Tennant did. Well, it's a daunting task to sue General Motors and the manufacturer of a seatbelt, another huge company with huge insurers involved, and an awful lot at stake for this young man. And the defense, very simply, was that Bill Tennant wasn't wearing his seatbelt. And he couldn't have been wearing his seatbelt because the seatbelt would have worked, because they have fail-proof processes for building seatbelts, and the seatbelt would never have failed. Well, the theme we developed for the jury trial was that seatbelts save lives when they work, and they work when all of their parts are in place. Now, we didn't get a verdict in that case because after several weeks, there was a settlement. There was an agreement not to disclose the amount, but it was a lot of money. And certainly the theme worked to the extent that very, very senior, experienced defense lawyers were prepared to settle on a substantial basis. The other case that comes to mind, Rob, was an equally fascinating case that involved another fine young man who, before the injury that went to trial, had suffered a spinal cord injury in a swimming accident. But he was a marvelous young man who, after his spinal cord injury, didn't give up and developed quite an education for himself, including a PhD in maths and physics, and was about to become a teacher in that role. And this young man used to get around on his own in a motorized wheelchair. And on the day of his injury, he was visiting a mall in a city in Ontario, and he followed the disabled signs, the graphic with the wheelchair, to a ramp up over the curb to go into the mall. As he was going up the ramp to get onto the sidewalk to go into the mall, his wheelchair flipped over backwards, and then he suffered, on top of his spinal cord injury, a brain injury. And that left him unable to work and needing care for the rest of his life. So once again, there was a lot at stake in that case. We sent an engineer and an architect out, and lo and behold, we discovered that the ramp was not built according to the building code, that it was too steep. And biomechanical engineers ascertained for us that the reason the wheelchair flipped over backwards was that the wheelchair, or the ramp rather, was too steep. So we had to figure out how to theme that particular case to avoid the risk that the jurors would conclude that this was probably his fault for somehow negotiating the ramp in the wrong way. So once again, somewhat similarly to the tenant case, we developed a theme that ramps such as this and accessibility signage, such as I described, were all developed to make public places safe for people with disabilities. And that was our liability theme. And it worked. We recovered a substantial verdict for this young man. And he too is now living his life in a good and safe way. Just two examples of themes, which I might mention to supplement Troy's point, took a lot of time and work with focus groups to develop.
Right. I remember both, but that second one, I wasn't on it. Gail Brock tried it with you. It actually went to the Court of Appeal. I don't know if you remember that, but Cadillac Fairview appealed, and you won the appeal. So if people are interested in reading the appellate decision, it's out there. Creaser versus Cadillac Fairview. Chris, in that case, our client's first name, he was a real underdog, having suffered quadriplegia early on in life, and then sustaining a brain injury while he was going to teachers college. Want to shift to Troy. Troy, have you used the underdog theme in any of your trials?
Absolutely. And we talk about it in the book because I think it's one of the most persuasive themes that really motivates people to care. And before I get to any of my cases, I'd encourage people to who get the book to read the McCullough case that Roger did, which is a great underdog story. Somebody who had all sorts of premorbid issues, and Roger did a great job in that case, painting him as an underdog to make jurors root for him. And it works. I mean, just think about movies like Rocky or Harry Potter or Rudy, if anybody's seen it, the football movie. Those are all characters who are underdogs, and you root for them because they're overcoming adversity. And I think it's just human nature to root for people like that because we all know them. And I've had lots of cases that have gone to trial where my clients have significant premorbid issues that have presented challenges. And if you can lean into that underdog theme, if the evidence supports it, of course, it can be very persuasive. One I'll mention is one where both the opening and the closing are in the book for people to read. And it's the case of Sarah Little and Sinton Bus Company. That's a case where our client was in grade 8, so at the end of elementary school, and she jumped out of the back door of a school bus on her last day of school and suffered a head injury as a result. And through investigation, we found out that had been going on in this bus for several years. It was a tradition that the grade 8 students would leap out of the back and run home at the end of the last day of school, and there'd never been any punishment, any consequences. The defense in the case on liability is that as a grade 8 who'd been a bus patroller the year before, Sarah should have known better. And on damages, their defense was around premorbid issues involving a sexual assault that she suffered when she was younger. And they argued that not only was she at fault for the accident, but her impairments flowed mostly from the sexual assault. So we lean into the underdog theme, or the vulnerability theme, probably more accurate in that case, to try to turn those arguments on their head, both on liability and damages. So the theme on liability was all about kids versus adults, and if adults don't enforce the rules, kids' safety is jeopardized and kids are vulnerable. And on damages, we very much lean into this theme that she was a kid who was particularly vulnerable to trauma, having gone through what she went through earlier. It would just make this head injury worse. So the themes that we developed, and again with lots of work in focus group, as Roger mentioned, positioned her as a vulnerable underdog who really needed protection from the adults who failed her. And they obviously worked. The case went to verdict, and it's one of those rare cases where a jury awarded every last dollar that we asked for, which doesn't happen very often. But I credit a lot to the work that went into the theming. It was pretty powerful.
A great case that you tried, Troy. Before we leave themes, I have to mention one. I thought you were going to talk about this one, Roger, because it's the one that really sticks out in my mind. And this goes back almost 25 years, a case that you and I tried. And our client, a young guy, 18 years old, drives his motorcycle into the side of a bus, suffers a tibial plateau injury, significant injury, and the medical evidence confirmed that he was going to need a total knee replacement, whether it was 10 or 15 years down the road, he would definitely need one. And the medical recommendations were that he should train for a sedentary job, a desk job. Josh Devitt, it went to verdict, so it's public record. But he was a hands-on, outdoorsy kind of guy. The last thing he wanted to do was sit at a desk and work for the rest of his life. He wanted to be an auto mechanic, and that's what he wanted to do. No one was going to tell him otherwise. And the defense theme, the whole defense was, well, you have a duty to mitigate. You train for a desk job, and you have no damages. Your theme, it was a great theme. I'll never forget it. You can't drive a square peg into a round hole. With the help of our psychovocational expert, that was the theme we used before the jury. You must have said that at least a dozen times in your opening, in your closing, in your examination and cross. And by the end of it, the jury accepted it. You can't drive a square peg into a round hole. And that's what the defense was trying to do. And they just didn't accept the defense position. And I've used that one because it's the kind of theme you can use in any kind of case. You don't need a catastrophic type case. And it works for just about anyone. So that's the one theme that really sticks out in my mind. Shifting gears to opening statements, guys. Let's talk about that. Roger, tell us just how important is the opening statement in a jury trial?
It's a great segue into answering that question, to think about themes. And I do want to emphasize, based on what both of you have been saying, that you may have multiple themes for a case. You certainly may have a theme for liability and another theme for damages. And it's great to be reminded about the square peg in the round hole, Rob, because that was a beauty, and I'd forgotten all about it.
I thought you forgot about it.
Yeah.
You've had so many.
But it's a great segue into opening statements, because as you talk about the square peg in the round hole, Rob, you realize how incredibly important opening statements are. I used to spend, as I know the two of you do now, days drafting an opening statement, because most lawyers who understand how people make decisions know that after a truly effective opening statement, you may well have gone a long way towards winning the right verdict, because you take advantage of primacy, namely the phenomenon that what people hear first, they're more inclined to believe. You take advantage of giving jurors the right themes so that they hear and perceive the evidence in the way that you want them to perceive it. You deal with all of the weaknesses in your case by inoculating, which we talk about extensively in the book because it's such a powerful, powerful strategy and technique. I can tell you one story that illustrates how important an opening can be. I remember a trial. I don't know which one of you was on the case with me, but it took place, I think, up in North Bay. And we had many, many weaknesses in this particular case. It was the Hoole case. And I inoculated against all of the weaknesses in my opening. And after the opening, the defense lawyer made his closing, and it was pretty weak. And that was the end of the day. And shortly afterwards, after just the opening and the closing, we settled the case. And the lawyer for the defense, who I didn't know at all well, said to me, you know, I knew after the opening that we had to settle because you had effectively dealt with every defense that we thought we had. I knew after that opening, Roger, that the case was over. The jurors had made up their mind, no matter what I said and no matter what evidence I led, it was just going to cost my client more money to go on with it. So that's an illustration of how important the opening statement is. I would go so far to say, Rob, that the opening statement is probably the most important part of a jury trial.
Yeah, absolutely. You said that to me 25 years ago and still holds true today. Troy, over to you. Can you tell us how does the advice in this book differ from what a judge might say to us about what a good opening is?
Yeah, just hopping on to what Roger just said about it being the most important part, probably. It's also the most exciting part, I find, as a plaintiff's lawyer, because you get to be persuasive. Judges don't see the purpose of the opening that way, frankly. Given their role, it's fair. They're focused on what's proper and what isn't. In the book, we quote from a Court of Appeal decision where Justice Cronk says this. I'll just read it. In an opening, counsel states what he or she submits the issues and questions between the parties, which have to be determined, are what are the facts of the case and the substance of the evidence that he or she has to adduce. That's what a judge might say an opening is about, but none of that's about persuasion. And from the lawyer's perspective, the opening has to be focused on persuasion. That's why we're there, and to take advantage of that primacy principle, which is very, very important. And we devote, I think, 3 chapters in the book focused on how to persuade jurors in an opening without offending the prohibition against argument. Because as Roger said, it is perhaps the most important part of a trial in terms of persuasion, even though, judges may not see it that way. It really is when you do a lot of jury cases.
Roger, you're the one with decades and decades of jury trials and experience. Can you tell us whether opening statements have changed over the course of your career? How they changed and if they changed?
That's a great question, Rob. I'll try not to take too long answering it. I had a jury trial fairly early in my career with a result that I wasn't at all happy with. I acted for a lovely young woman whose shop teacher bumped her hand into an unguarded table saw and severely injured one of her hands. And the defense lawyer was simply better than me. And we got a verdict, and we got some money, but it wasn't nearly what she was entitled to. And I was pretty disappointed in myself. But I decided at that point that I needed to learn something about how to present a case to a jury and how juries made a decision. So I started going to courses and reading everything I could find. And many of the courses were in the United States. And I came back to Ontario armed with all of this new information. And I started winning jury trials left, right, and center. And I remember a blitz to get rid of the jury list in Barrie, Ontario. And I tried 3 cases after another, one after another. And we got more than had been offered in all 3 cases. And we were just flying. And then I had a trial where one of the judges in Ontario took great issue with some of the techniques that I was using. I'd already written the first edition of the book, and I realized, because this judge went very public with his criticisms and gave a speech about it at a law conference, I realized some of my ways had to change. I had to start being much more skillful and careful about the way I spoke to juries in my opening. In fact, one day I had lunch with Justice Mary Ann Sanderson, who was a dear old friend, who said to me that during a jury trial, she had to stop a lawyer and tell him that he could not say what he was saying. And he said, of course, the jury has left the room. He said, "Well, it's in Roger Oatley's book, Your Honor." And she said to me over lunch, "Roger, you've got to do a second edition and make it right." So that was what gave rise to the second edition. We haven't changed the techniques for the third edition, but I can tell you that as a result of the courts pulling me back, there have been definite changes. No longer do we use any of the well-worn old phrases like, "Ladies and gentlemen of the jury, it's a great honor for me to be representing Mr. So-and-so or Miss So-and-so on this trial." It's a case that is about much more than my client. It's about what's good and moral in the community, and how we as a community should respond to people in need. That sort of nonsense is now gone. We have to instead be much, much more careful that we do not argue our case, and instead that we very skillfully order the facts in a way that makes our argument without it without asking the jurors to come to a particular conclusion. And I think that's the key difference that has evolved over the years, to order the facts so that they speak for themselves. Avoid any attempt at legalese, and be certain you do not tell the jury what you want it to conclude.
Absolutely. By the way, Roger, it was 6 trials you had during the Blitz, not 3. 5 of them went to verdict. The 6th one, we settled about a week in, and you're too modest to say, but you got solicitor and client costs on all 5 of those verdicts. I'll never forget it. Anyway, it's a nice trip down memory road today. Let's fast forward to today. Troy, you've tried more cases than any other plaintiff lawyer that I know in the last 5 or so years. Tell us, are modern jurors different than jurors were 20 years ago in terms of what works and what doesn't work in an opening statement?
I think the short answer is yes, that they are. I think the way that people take in information, process information is different now than when I started practicing law, which is a little bit more than 20 years ago. Attention spans are shorter. We talk about this in the book, and there's been studies on it. There's actually a lot of social science research that's summarized in the book that is really, really interesting and helpful to understand how jurors think. There's a study done in 2015 that said people's attention spans dropped by 1/3 between 2000 and 2013. And they've probably dropped more since then, because we live in a smartphone society where people consume information in short clips. So there's a difference. A modern juror isn't going to be able to maintain the same attention that somebody might have 20 years ago. So that, the days of hour-long openings are over, or they should be. I think the other big change is that we live in an increasingly digital age. And there have been all sorts of studies, which we talk about in the book, on that. Modern audiences, whether they're jurors or any other audience, they simply retain information better when there's a mix of communication and visual aids. That's been researched and proven. And that's why it's really important in the opening statement, for example, to include demonstrative evidence, both to keep people's attention, to promote learning, to allow for repetition that isn't boring. Roger is modest, but he pioneered demonstrative advocacy in Ontario. It's one of the reasons I left a firm to join Oatley Vigman, because Roger was a pioneer there. But Roger, I think it's even more important now than it was when you pioneered it, because of the people that we have in jurors in 2025. And it's so important that we added a whole new chapter to the book on the power of demonstrative evidence in this edition that didn't exist in the previous ones.
Yeah. And I should mention, speaking about modern technology, this current edition of the book has an audio supplement. So anyone who buys the book will get this audio supplement, and you can actually hear the opening jury address in Little versus Sinton. That's the case that Troy tried a few years ago. So that's a nice little bonus from LexisNexis. Shifting gears now, guys, to this concept of inoculation. And Roger, this one's for you. When you have a problem area, usually based on focus groups that we've done, what strategy or strategies do you use to deal with it?
Rob, it's a wonderful question. Allow me a small indulgence to just add to your comments about the audio supplement. It's not only Troy's opening, but his closing. And what's so effective about it is that Troy and I did this together, and at each step of the opening and the closing, I jump in and I give the listener an explanation of the strategy that Troy is about to use. And modestly, I have to say that after going back and listening to it, it is really, really good. It's the most incredibly effective way of if you can't try a case with a good experienced lawyer, it's a very effective way of listening to how a good lawyer presents an opening and a closing with somebody who understands what's going on, supplementing it with explanations. I mean, it's a huge, huge improvement that comes with the third edition. But to back,
Yeah, I was just gonna say that's awesome, guys. I'll have to listen to it. I'm not an audiobook guy, I must confess, but some people are. To tell us a little bit about how you inoculate against weaknesses.
yeah. Um, the book goes into this extensively because it's such an important skill. And I want to, again, pause for a second to remind people that none of this is an art. It's a skill that everybody can learn if you want to put in the time and the effort to become a good jury lawyer. Every case has difficulties. There isn't a case, the three of us have never had a case where there aren't some weaknesses in it. And inoculation is the most brilliant way of dealing with them. Effectively and simply, what you do to inoculate is acknowledge the weakness, acknowledge the defense argument that is coming, and acknowledge how it damages your case if it's true and if it's accurate. But then you go on to explain why, for whatever reason, it doesn't affect your case, or it isn't accurate, or it isn't quite what it seems, or there are other explanations. You thereby take the sting out of the weakness. You take the sting out of the defense argument so that by the time the defense raises it, the jurors are thinking, well, we already know about this. We already know what the answer is. So go ahead and take the time if you want, but it's not going to impact us very much. It's a technique that was actually developed, we're told, during the Second World War to make propaganda effective. And it absolutely works, and you can use it not only in jury trials, but in negotiating settlement of cases and at mediations and every other situation in which you're trying to persuade. A really good example, as Troy said, is the one in the book dealing with the McCullough case. This was a case that had all kinds of fleas on it. Our fellow had been very, very seriously injured in an accident where he fell off a roof. He was a roofer. And the problem we had was that he really wasn't that likable a guy. He'd never paid any taxes. Like a lot of roofers, he'd always worked for cash. And people don't like people who are dishonest and don't pay their taxes. He'd always had a problem with alcohol. Being a recovering alcoholic or a not so recovering alcoholic all of his life. So we had to figure out a way that we could inoculate against those weaknesses. And the really interesting thing about it is that if you inoculate effectively, the weaknesses can actually become strengths. So what we needed to do in this case was acknowledge the weaknesses and then explain that this poor fellow had been orphaned at a young age and had been separated from his siblings and brought up in one foster home after another, and that he had developed a stutter. And we explained that this poor guy, John McCullough, didn't like to use alcohol, but that he used it because it gave him confidence. And when it gave him confidence, his stutter went away. And we also explained his failing to pay taxes on the basis that he had to do it to survive and to support the children from whom he was estranged. He became such a sympathetic fellow by inoculating this way that I think the defense became reluctant to use these weaknesses against him for fear of making him all that more likable. It's illustrated quite extensively in the book, and believe me, it's a skill that you have to develop in order to become a good jury lawyer, probably a good trial lawyer, period.
Absolutely. Now, Troy, the McCullough case was Rogers, of course. Can you give us an example of one of your cases where you use those same sorts of strategies to inoculate against a weakness?
Yeah, no, fortunately, I've never tried a case with so many apparent problems as that McCullough case had. That case was before my time at the firm. And Roger, when I first read the opening, I thought, oh my God, I would have never tried this case. But the way you turned him into an underdog through the inoculation was really brilliant. In the book, I talk about a case called Scucci and Stevens that went to trial a couple of years ago. Right, I had the same issue when I got into the trial prep. It was tough to find likability in the client, and there were pre-morbid issues. He also didn't pay his taxes. But it comes down, and I learned this from Roger, to spending a lot of time with your client in prep and finding the details where you can explain away the weaknesses and get evidence that the jurors will find to be likable. And in that case, he had an issue with anxiety beforehand. That was the main prong of the defense on damages. So we spent a lot of time strategizing about inoculating, and we had to acknowledge it, as Roger said, and deal with it, and then put it in context. We did that through evidence from the family doctor and experts about just how prevalent anxiety is in the working population, explaining why he was having anxiety, and then trying to flip the argument on his head in the same way we did in the Little trial by, based on the evidence, painting him as particularly vulnerable. So if you do spend a lot of time and effort in trial prep, there are opportunities to inoculate against these defense arguments and turn them into strengths. But that's all I'll say, because McCullough was such a masterpiece. So I'll just say to people listening, read that opening, because it's a masterclass in inoculation.
Yeah, thankfully there was only one McCullough case.
Roger,
you wanted to add something?
There's a quick point to be made, and that is, if you're preparing an opening, and I always had a heading in my first draft, inoculations. And if you find yourself spending pages and pages on inoculations, there is a point at which you'll say to yourself, we got to get this case settled.
Good advice.
Absolutely.
Let's talk a little bit about decision-making biases, generally, which you talk about in the book. And the book explains the importance of belief systems and decision-making biases. Roger, can you tell us very briefly what they are and how they differ?
Okay, very, very briefly, because we are running out of time. Belief systems are different than decision-making processes. And the best way to explain a belief system and what it is to give you a couple of examples. One belief system is that you have to see an injury in order for there to be one. Another one might be there needs to be serious damage to an automobile for someone to have been seriously injured. Another one, and to the ladies who are listening, I'm not suggesting this is at all accurate, but another belief system might be that women seldom work as long as men do. Another one might be doctors are pretty much infallible. They always know exactly what the problem is and how to solve it. Those are belief systems, examples of them that people come to a trial with. They develop them over the course of their lives. That's very different from decision-making so-called biases. And they aren't really biases, they're what sociologists call heuristics. They're ways in which human beings from the earliest of time, probably back when we existed in tribes, learned to make decisions in not necessarily conscious ways. Decision-making biases are absolutely critical to understanding if you're going to be an effective jury lawyer. And I'll turn it back to you, Rob, with that quick explanation.
Right. Thank you, Roger. Troy, this one's for you. How can we learn about decision-making biases that might play a role in some of our cases?
So I can tell you how Roger learned about it, and then later how I learned about it. There's been a lot of research done in social science fields like psychology, and in the United States, research relating to jurors, because they're able to talk to them afterwards. Maybe the best way for people to learn about it in terms of how it impacts Ontario and Canadian jurors is to read the book, because we spent a lot of time reading the research and summarizing some of the real key decision-making biases that are at work in personal injury cases.
Excellent. I know we're running out of time, but I do want to touch upon a couple of other things if we can. You talk about the defensive attribution biases that we see in some cases. You talk about a number of decision-making biases. Troy, there's a section on a defensive attribution bias. Can you tell us about what that is and how to deal with it?
Yeah, this one's really interesting and important in what we do, because it can drive contributory negligence in a lot of injury cases, and particularly serious injury cases. And it can be summarized pretty simply like this. People have a tendency to see someone injured and think that wouldn't happen to me. And that's what the defensive attribution bias is. And it's something deeply rooted in the human psyche. People have a need to feel safe in their world. So it's natural, I think, for people to think good things are going to happen to good people like me. And if bad things happen, they happen to bad people like that person. And it's not just injury cases where we see this in a legal aspect. It's very, very prevalent in criminal sexual assault cases too, where jurors are trying to distance themselves from the victim. And it's, I think, just deeply rooted in the human psyche to want to do that. And the research shows, and this is really interesting for me to read, that the worse the injury, the stronger the bias is. So the more catastrophic the injury, the more jurors will look to find the plaintiff at fault. So it's something you got to absolutely be aware of in every case where you've got a serious injury and contributory negligence as an issue. And there's, we talk in detail about this, but there's really two key strategies in my view to overcome it. And one is to keep the focus on the defendant's bad behavior and make that the focus of the trial. And the other is to lead as much evidence as you can to show that your injured client is a good person. That's simplified. You can read more about it in the book, but it's a real important decision-making bias that I find absolutely interesting in terms of why our minds think that way, but they do.
Rob, let me just say a few words about biases, because we just have a minute or two remaining by way of wrapping it up. The key skill for a good jury lawyer is to understand what biases may affect a trial, and to deal with them if they're against you, and to take advantage of them if they're going to help you. And these biases are so important. Troy has said that, and I just want to underline it. You cannot try a case in front of a jury without effectively understanding them, dealing with them, and taking advantage of them. I wish we had the time to go into them all, but we don't. We don't have time to deal with belief systems in detail either, but that's what the book is for. Troy and I had a great time improving from the second edition. I have to acknowledge that Troy did most of the work, and I appreciate his efforts immensely. And Rob, it was extremely good of you to write the introduction to the book, which Troy and I both appreciate.
It was my pleasure, Roger. It was great to see you guys, especially you, Roger. Haven't seen you in a while. Thank you for doing this. Before we go, I just want to show everyone why we're here. Roger Oatley, Troy Lehman, authors of Addressing the Jury, 3rd edition. It's a great read. It's an easy read. And don't forget the audio file where you can hear Troy's opening and closing in the little case with Roger's commentary. Thank you, guys. Good to see you.